Good morning, everyone. We are live. This is Amy Peikoff, and I am joined once again by esteemed constitutional scholar, lawyer, and author Bruce Fein. This is the normal weekly Fine Points. We've had a lot of conversations with Bruce in the last couple of weeks because the Supreme Court was releasing, kind of dripping out each day the opinions, the final opinions of the term. Today, as I understand it, Bruce, we've agreed to talk about some of the effects of the last and what some people take to be one of the most important rulings that the court issued at the end of its term, which is the immunity ruling, the presidential immunity ruling in Trump versus United States. Is that correct?
That is right, Amy. It's already finding reverberations in the New York, what you call colloquially the Stormy Daniels Cape 34 felonies. It's got reverberations already in the Florida case Mar-a-Lago, where it said at least when he was in the White House, Mr. Trump dreamed that he was declassifying documents. So it's a presidential act, even if he didn't attempt it physically to do it until after he was. And in the Georgia case, which has been in hold because an appellate court is determining whether Fani Willis should remain as the prosecutor. So the fallout is very pronounced, and we do not yet have even any hearing scheduled in the January 6th case, which was the case that provoked the ruling,
Right.
On remand to decide what may be or may not be a presidential act that's protected by, if not absolute, presumptive immunity. And here, I feel it necessary, Amy, and I'm apologizing to the audience who doesn't necessarily and wouldn't expect to be skilled in some of the arcane elements of procedure. But it's important to understand procedure in order to realize the real world effects of the decision, which purports to divide presidential acts into absolute and presumptive immunity with a very opaque standard between the two. But in 234 years, not a single court has ever opined on the issue because it was never raised. So there's no outstanding precedence.
Right.
And the standard that the court provided is like, in its terms of its vagueness, it's a reminder of Potter Stewart's definition of obscenity. I know it when I see it.
Let me ask you a question on that, right? Because I have not read the full opinion, but I've been really reading the syllabus and trying to digest the sort of categories and what they mean. And again, it's going to depend on how they apply certain bits of language in the lower court when they finally do have the hearing. One thing that was fairly clear to me was the category of actions to which they would apply absolute immunity.
Yeah, they gave one example of that, namely a president's law enforcement decisions, who to investigate and who to criminally prosecute. That was said, but they gave no other examples. That's the only.
Right. But what I'm saying is that the principle behind that category made some sense to me. So you can tell me how I'm wrong, because
okay, I can interject right now, Amy.
Well, no, but let me just
tell you why it's. I can tell you why it's wrong.
It has to do with his exclusive authority. So if the president has exclusive authority about something, then they say he has to have absolute immunity. But everything else where he either doesn't have authority or he shares authority, only the presumptive immunity. That was my understanding of the breakdown. That seemed relatively clear. But I agree with you about the presumptive immunity, that's completely vague and opaque, and to figure out how that's going to apply is
let's think of this hypothetical, and they were hypotheticals at least were suggested by the dissent, so that had been surfaced before the majority actually issued publicly their opinion. Mm-hmm. Suppose the president says, okay, I have limitless authority to decide who to criminally investigate and prosecute, and he calls the attorney general and says, here, my friend Elon Musk is going to give you $100 million. You go immediately investigate Joe Biden, the head of the Democratic National Committee. I don't care what it is. Make it up, make it public, announce it, and we'll be able to blacken the name before anything begins. Even if it doesn't go anyplace, you stick the FBI on there. You issue subpoenas. I don't care whether they all fail. We want to get in the public domain the fact that we are investigating X. Could be child molestation. It could be serving as a foreign agent for China or whatever. And that under the standard announced by the Roberts opinion is immune, absolutely immune, because it relates to law enforcement.
To his exclusive authority. Okay. Wow.
Now, let me give you another example, Amy, that I think is equally explicit in the Constitution. That is, the president clearly has the authority to grant pardons for federal offenses, right? No doubt about it. It's explicit. Suppose somebody, Steve Bannon, okay?
Right.
He gets his friend to pay Trump. Soon, maybe Trump gets reelected. Here's Mr. Trump. Here's $100 million. Give me a pardon. He says, okay, good deal. He issues a pardon. That's immune from criminal process. It can't be charged as bribery, even though bribery is one of the offenses that's listed as an impeachable offense in Article 2, Section 4. So, I mean, I don't know what these guys were thinking. Of course, we understand that presidents can have broad authority in some respects, but virtually no authority in the Constitution is limitless without any check whatsoever. We don't, it's like goes back to Reagan, trust but verify. You got to have some limits on everything. Otherwise, where the law is over. I mean,
so would you, with respect to that category, you wouldn't say, okay, well, Congress can do things to limit it necessarily, but at least the court would be able to look at the Constitution and decide whether he was acting within the scope of this authority that was exclusively delegated to the president per the Constitution, that would be a court's proper role?
Well, I mean, the court said that Congress cannot disturb its decision because it's
Right.
constitutionally based. So Congress can't do anything to undo the decision.
Right.
But I want to give another example, Amy, that's rather alarming if we think about the 1920s and 30s of the Third Reich in Germany. Suppose the president said, I want you to go over and arrest every single member of the Supreme Court who voted against me on this immigration case and put him in prison. That is protected. As you pointed out, the language was anything related to law enforcement, who to investigate, who to prosecute, is immune. Really? You can shut down the U.S. Supreme Court? Suppose he did that to his adversaries in Congress. Is that also?
So their argument would be, well, it's impeachable, so that's the remedy. Is that the idea?
Yeah, he could lock up all the people in the House and the Senate so they wouldn't even be available to vote on impeachment. So, I mean, it's never been the case for any other defendant ever to say, well, as long as you might be able to be impeached, then you can violate the criminal law. I mean, which is ridiculous because the whole purpose there's recognized that impeachment, unlike a judicial proceeding, because the members there are elected, they're going to be partisan. They belong to largely the Democratic or Republican parties. It's not going to be a judicial proceeding where everyone has got to be impartial. They take oaths. There's rules of evidence and whatever that exclude inadmissible, unreliable evidence. That's why you get in a court of law. That's why you have a criminal prosecution there, because you can, at least it's not everything, but you are guaranteed safeguards to ensure impartiality.
Okay.
I mean,
so really where this particular ruling about, the events of January 6th and et cetera, is going to, sort of focus on the presumptive immunity category. It's not going to be the absolute immunity category. But you're saying even with respect to that absolute immunity category, this ruling is wrong in your opinion?
It's frightening. And remember this, and if my audience say, oh, Mr. Fein, you're just exaggerating, and I tell I never voted for Biden or Trump for anything. If you just want to know my political inclinations, I think both parties are actually disreputable. But this is the dissent of Sonia Sotomayor. And remember, the dissent is known to the majority before it issues an opinion. So if it wants to cite particular language in the dissent that it disagrees with, it can say, the dissent exaggerates. No, this would not be protected. Okay, so let's look at the portion of the dissent that the majority opinion did not state disagreement with, except at an overall 80,000 feet saying, well, the dissent's reasoning is flawed. That's all it was. One of the things the dissent said was that what the president could do under the majority opinion was to assign SEAL Team 6 to go assassinate a political opponent with impunity. Okay? That's in the opinion. It's not what I made up. It's in the opinion that was known as a hypothetical presented in the dissent. The majority does not say, oh, that clearly would not be a presidential act, couldn't possibly be protected. That's shocking to me. It's more than shocking to me.
Right.
And that's why, I know the language sounds, well, it's just exaggeration. It's not. Read the opinion. Think of hypotheticals that were already presented. They didn't deny any of it. And I know how the opinions get circulated, Amy. I've been up there.
Right.
Well,
yes.
Everybody knows all the opinion and has a chance to look at it before they're issued. The majority knew about this. Another hypothetical that the dissent presented. He could undertake a military coup and put the country under military martial law. Did the majority say, no, that clearly wouldn't be constitutional, not be a presidential act? No, silent. So that silence means, Amy, that when the case goes back to the district court, which it should be probably soon, okay, these are all on the table. That is, because there is no track record on this issue, since it hasn't been raised in 234 years in the judiciary, they're right on a clean slate. There's nothing that makes any argument out of bounds. And that's so that even today, the argument that Trump's people can make at the trial level and up again is, the president can assassinate his political opponents as part of his law enforcement discretion. Okay? So even if it ultimately loses as a practical matter, and this is where I want to apologize for the audience because it's kind of technical, but it's very important as a practical matter. The court has said that when a defendant claims immunity, if he loses before the trial can begin, it gets to go up on appeal. And then after it goes up to appeal, then it goes back up to the Supreme Court. You know how long that's going to take? Years. Every single immunity decision, argument made, even if it's just presumptive immunity, by a president or former president, will not be resolved for years.
They didn't provide for any expedited procedure for this or anything.
None whatsoever. Okay. None. And in fact, in this particular case, when there was an effort to ask the court to do an expedited procedure on Trump v. US, the court said no and held it to the very last day of the term. That was, and Amy, just in terms of comparisons, the court took the case in February of 2024, and then they decide July 1st. Now, how about cases similar? I was involved in. Okay. Take, for example, Bush v. Gore, decided in 48 hours.
Right.
Bush v. Gore decided 48 hours. Take Nixon versus U.S. The tapes case, 14 days. The Pentagon Papers case on Daniel Ellsberg and the secret Vietnam War disclosures, 4 days. The court knows how to gallop instead of walk. It chose here purposely to walk. So you ask, why? Why?
We can relate it to the Alita flag incident and stuff, but yeah.
Yeah.
Anyway.
So, anyway, listen, I'm someone, Amy, I presume everybody in government, I give them a presumption of honesty and sincerity in, their decisions. I don't ever presume anyone's corrupt. Even if I disagree, I figure, okay, well, people can have different understandings and whatever. But the irregularities here are so pronounced. We just happened upon one thing, but the other element that's very, very irregular is that the court's opinion could not point to a single syllable of text in the Constitution which supported its result. None. This is a textualism court, right? Start like Scalia, or you start with the words, right? And what do the words say? And you take what would the framers at the time of the founding interpret those words to mean?
Right.
Okay. At the time of the founding, let's go back. Like I read volumes about the founding period, 1770, 1787, and I ask myself, if at the Constitutional Convention and George Washington presided over the convention. James Madison was the chief scrivener. Say Madison stood up and said, well, under Article 2, we're going to give the president absolute immunity to commit any crimes he wants. I mean, Amy, you think that document would have been ratified? There is zero chance, right?
No.
And so if you're trying
I mean,
to go back,
I did my little reading of the Declaration of Independence on July 4th, right? Which is a nice tradition to do. And when you think of what they were complaining about in terms of King George's actions, it seems very clear that no, they would not have ratified such a thing, right?
No way. I mean, they were complaining the denial of jury trial. You're dismissing Parliament. I mean, the assembly, so they have to meet and
taxes of various kinds.
Yeah. I mean, anyway, George Washington, he's sitting at the convention, says, "Oh yeah, I need to have protection against committing crimes." I mean, it's even this.
Let me ask you this question, because the thing that they kept pointing to, the only thing they could point to was that somehow there was an intention to have a vigorous, a decisive, I can't remember all the adjectives or adverbs, executive that they wanted. But is that anywhere in the Constitution that they contemplate this? It's just lore of some kind.
It's made up as a matter of policy. And let us think as well, Amy. They derive that in part from one of the Federalist Papers that Alexander Hamilton authored. I think it's Federalist 65. But they ignore two other Federalist Papers of Hamilton. 69, where he says, oh, the president is commander-in-chief. Isn't it all going to be like the British king? The British king can raise armies on his own, go to war on his own, make treaties on his own. All those powers under our system belong to the Congress. All the president is as commander-in-chief is just head of the armed forces. That's all. He likened the president to like a governor ruling the National Guard, the state militia. That's how they like. Now, that's not a president that bestrides the world like a colossus, right? That's a very modest president, and saying specifically, it's not like the king. And remember, one of the other things that the king had that the president did not is the king can do no wrong doctrine, right?
Right.
He didn't have that. Then there's a Federalist 75. This is the treaty power, where Hamilton says we can never trust the president with initiating and concluding treaties on his own. He's untrustworthy because he's going to have ambitions. He may be bribed. You remember one of the background of the treaty power was that Charles II was bribed by the French king to join an alliance against the Dutch, in a war. He got lots of money because he couldn't raise the money from Parliament. So the French king gave him money. And so they knew about that and said, no, we're not going to print that. So we were requiring ratification by the Senate. That doesn't sound like somebody who believes, oh, yeah, the president is going to be a saint and an angel and he can do anything he wants. So there's nothing in the text of the Constitution that says, oh, the president's supposed to be aggressive. In fact, what he's supposed to do in the text is faithfully execute the laws. Execute means comply with them, right? Not sabotage them. So to the extent you can draw an inference from the express language, it says, sure, we want a president able to discharge the powers that we've conferred, but we haven't conferred upon him power to violate the law. He's supposed to execute them.
Yeah. And so impeachment is really not enough of a deterrent in your view for him to go beyond his explicit authority.
No, it's not. It's not. Listen, it's just that we ordinarily have sometimes multiple safeguards. And one of the reasons why impeachment is not a trustworthy safeguard is that, in contrast to the judiciary, judges appointed for life, they're independent, supposed to have a duty of impartiality, they don't have to run for re-election. It's not that they can't have partisan elements, because obviously they're nominated and confirmed through a political process. But once they're confirmed, they're not. But the impeachment process is highly political because everybody's there, because they belong to the Republicans or Democrats. They campaign, they're up for re-election. They get campaign contributions. There's no conflict of interest that requires them to recuse themselves, even if the president gave them $50 million in their district to build XYZ. So it doesn't have at all the security that a judicial system has, as imperfect as it is, to reach a right and correct result. Um, so that's why the impeachment process is not a substitute for a criminal prosecution. Now, the other thing that's related to impeachment, however, really militates against the court because it specifically says in the impeachment clause that if a president, is impeached, he can also be subject to criminal prosecution, after he's removed from office. But here we're talking about presidents that aren't even in office anymore. It's not like you're handcuffing them. Well, the Chinese or the Russians are launching ICBMs against us.
Right, right.
He's not in office. He doesn't have any responsibilities. So where's the danger to the country?
Okay. So they would say about that if you had in mind that you could be prosecuted for whatever you're about to do after you get out of office, that it would hamper you in the, execution of your official duties while you're in office. That thought that it could lead to criminal prosecution later. And they say, explicitly that it's not civil damages that would really hamper you, but it's the criminal prosecution. The threat of that in your mind would hamper you while you're performing your duties as president. What do you think about that?
I think that's fanciful. Okay. There's been 234 years elapsed in the country. There was never anything even close to that hypothetical. In fact, the only thing that came close was Nixon and Watergate, and I was involved in that. In the Nixon case, it was clear that he was in the Oval Office. When he's talking with John Dean and Haldeman and Richard Helms, cover up the money that went to the burglars by saying it was national security CIA money and telling Haldeman, well, lie about, what you can remember about the Watergate break-ins. He's in the Oval Office, right?
Yep.
Now, he then is not in office anymore. He resigns under the cloud of impeachment. And the reason why a pardon was issued by President Ford, and Nixon accepted the pardon. You can't be compelled to accept a pardon if you don't want one, because you're conceding you get a criminal act. Otherwise, you would need a pardon, right? Is because they all thought he could be criminally prosecuted. And Jaworski still had a standing grand jury. It was more than just a speculation.
Sure. The case never had to be decided because the pardon was issued, so there was never a ripe case to adjudicate there. But so then someone like a Vivek Ramaswamy would say, we're in a different era now, Bruce. We're in an era where this sort of prosecution is somehow influenced by the president, the current sitting president or his allies against a former president who is also his political opponent. And so now we actually do have to ask this question because I guess the culture of our country has deteriorated to such an extent that this is something that is happening now but never happened before, this politicized prosecution. What do you say to that?
Okay, it's a wonderful argument. Before I get there, I just want to inform the audience. Nixon, while he was president, was named as an unindicted co-conspirator in the cover-up trial. So he knew it wasn't just speculation that he might be indicted once he was out there. This was already sort of Damocles over his head. But with regard to the argument, well, we live in a different era. You know what? That sounds to me just like the theories of Earl Warren and all the liberalism that this court has denounced. Say, no, we don't have a living, breathing constitution that kind of grows like a tree when you fertilize it, and it then develops new issues and it kind of amends itself without changing the text. Really? That is exactly what this court has repeatedly said. No, that's why it overruled Roe v. Wade and Planned Parenthood and Danforth, saying this is ridiculous. The Constitution is the Constitution. If I would ask the critics, okay, well, show me what part of the Constitution has changed. What is the wording in the Constitution that's changed? Didn't go through the Article 5 amendment process. And if he thinks that the amendment is needed because circumstances have changed, good, we have Article 5. Go ahead and amend it. There have been, and by the way, 5 constitutional amendments have responded to Supreme Court decisions that were thought to be erroneous. 5. So you have a path laid out for you. You think things have changed. We need to amend the Constitution, write in new words. go ahead and propose it.
So
But
there is a third path, and maybe at some point we'll have this discussion, but you have talked about this original meaning version of constitutional adjudication. And then of course there's this living constitution uh, idea where you can just read into the Constitution stuff that really isn't there. But a third path has been discussed extensively by Professor Tara Smith at UT Austin. And she talks about the fact that whereas the concepts and the principles in the Constitution remain the same, our knowledge about the facts in the world that are reference or instantiations of applications of those principles or concepts could change over time. So a third path would be to say the language of the Constitution is the same, but we only understand the full meaning of the concepts and the principles now in light of facts that have come to our awareness since the time of the founding. And I could say it's a bit of a judgment call maybe to say, how do these concepts and principles apply to a situation in which it is very politicized and there are prosecutions. I'm not telling you that I disagree with how you might come out about that, but I'm saying that does add an additional wrinkle if you would accept that as a valid theory of constitutional adjudication.
well, I don't, for a very simple reason. You have to point to the text to come up with a principle. You have to identify the source of the principle, right? That you say.
So you think this is so far removed that you can't even say that there's something there that you're applying in a new context?
Yeah, there's no
okay.
text.
Okay. Okay.
So there's no text to apply. Moreover, if you take this court, they've always said that when you take the text, you interpret it as to how it would have been understood by those who authored it at the time the Constitution was ratified.
Right. That's the original meaning version of originalism, right?
Okay, but if you don't take that standard, everything else is a subjective standard. I mean,
yeah, and that's where Smith would disagree. So maybe we have her on and you talk with her at some point. That would be a very interesting conversation.
Okay, but all I would say, Amy, is this: if you don't use the understanding of that time, how do you decide what the current understanding is? Who decides?
You talk about, well, each individual judge would be objective about the facts and how they would actually.
But there's no objective standard. I mean, how do you decide how it would be? I mean, everybody views it differently, Amy. Yeah. I mean, we even go to the Supreme Court. We find 5-4, 6-3 decisions all the time. They are not dumb people.
Okay, so we have to have a discussion between you and Tara Smith, because she's applying, Ayn Rand, her objectivist epistemology, to questions like this, and it's a complex theory that we're not.
Okay, but I would say, you do a Gallup poll and do a Gallup poll out there before.
No, it's not a Gallup poll. It's not a Gallup poll. But it's arguments about objectively what are the reference in reality that you can point to the reference of a particular concept or a particular principle or rule. And she thinks that you can have an objective theory of adjudication along those lines. But this, again, it's beyond the scope of our discussion today. Okay. So going back to this, you think that there's not language in the Constitution to support what the court did, and not even with respect to the absolute immunity category, and certainly not with respect to this presumptive immunity category. My next question for you was, with respect to the 3 cases that you listed, the ones that are going to be affected by this ruling, we're talking about the 34 felony convictions in New York for changing the business records, et cetera. We're talking about the Mar-a-Lago documents case, and we're talking about the election interference case. I forget the exact charges in Georgia, right, with respect to the election there.
The fake electors.
The fake electors. So with respect to any of those, would you say that all of those are in the presumptive immunity category as best as you can tell from, or arguably, that's what they're going to say, they're arguably in the presumptive immunity category as laid out by the court in this case?
Everything that the president does, according to the court, is presumptively immune. Even if you went out on Fifth Avenue and shot somebody in the head. As long as
They did say about unofficial acts, though. They said unofficial acts, no immunity. So this is in the outer perimeter of official acts. Yes.
No, they did not say that, Amy. And they gave no examples of, well, what's an unofficial act that they gave an example of, Amy?
No, I didn't see. Like I said, I haven't read the entire
They
opinion.
don't. No, they don't. They didn't say unofficial acts. They basically are suggesting if it's not presumptively immune, maybe it's an unofficial act. But they said everything that the president does while he's sitting in the White House, 100% is presumptively immune. And you can only override it if the government discharges the burden of showing the criminal prosecution will not interfere with the authorities of the executive branch. And nobody knows what the interference is, because there are no cases out there, nothing. Now, a couple of other observations I'd like to make. One, it's not just me who says there's nothing in the Constitution. Here's a copy of the Constitution right here. Mm-hmm. I look at it every day. The court was unable to point, and I challenge anybody on this show to find a single word in the Constitution that suggests any kind of immunity for the president.
Right.
Point it out. Mm-hmm. Okay, they got plenty of time up there. They got 4 clerks, each one of them. It's not like they were rushed because there isn't any. It's just made up out of thin air. It's just made up out of thin air. Is Roe versus Wade? At least Roe versus Wade at least tried to summon penumbras and emanations. You know,
right.
They didn't even rely on penumbras and emanations. They just said, as a matter of their policy preference, we want a president who's really tough. You know, who does whatever he wants, takes a wrecking ball.
Vigorous,
and where does that come from? Where does that come from? I mean, if there was anything, Amy, if you read the Federalist Papers, Madison, who was the chief intellectual author of the Constitution, he says, and the framers believed that the most dangerous branch was going to be the legislative branch, because it was entrusted with huge powers, the power of oversight, the power of declaring war, power of the purse, all of that. He's always writing, hey, we really got to be safeguarded against Congress, because he saw Congress was the first among equals in the Constitution. So where does he get this idea that they intended the president to walk, let's say, like a Caesar around the world? It's just invented. Mm-hmm. Now, insofar as they could see, as like you and I can see and everybody on this program can see, the president has become de facto, not under the Constitution, a virtual Caesar, goes to war on his own. They can say, hey, we need to ratify that. But that's not in the Constitution. Even if he de facto is, it doesn't make it constitutional. It just means it's a political fact. Just said, but he's still not an imperial. He's not a king. Even if he acts like a king, he's not one. He doesn't have this kind of immunity. And you need to amend the Constitution if you want to change the Revolution of 1776 and the Constitution of 1787. There's an Article 5 process to do that. And go ahead. Even if they think your decision is wrong, there's no immunity, go ahead and amend it. As I stated, there are 5 other times Supreme Court decisions have been reversed by amendment process. Go ahead and do it. That is the way that a democracy, a rule of law system operates.
Right. So practically, the effects have been, first of all, that the sentencing hearing in the New York case has been postponed until September. Is that correct?
September 18th.
And did that seem like a reasonable measure for the judge to take in that case?
I have authored a letter with some others to the judge. It said, there is a rule, Amy, in criminal justice called harmless error rule. And if evidence was improperly admitted that was harmless beyond a reasonable doubt, considering the overall volume of incriminating evidence, then you just ignore it. As the Court of the United States has said, Supreme Court, you are entitled to a fair trial, but not a perfect trial, because it stumbles all the time. Now, in the one instance where the New York trial may have encroached on the presumptive immunity, or even say it's absolute, is that after the president was elected and Michael Cohen was demanding, hey, I need to be reimbursed for all the money, we paid off Stormy Daniels. I paid her off at your direction. Hey, you got to pay me off the money because I did the favor for you. Mm-hmm. That was used in part to prove that there was, in fact, a payoff scheme. Okay. But that's a very tiny slice remember, the trial, Amy, was 7 weeks, 22 witnesses. Trump didn't take the stand. It took the jury 11 hours to get a unanimous verdict on 34 felonies. That is supersonic fast. That is, it's clear the jury had no doubt in their mind that there was guilt. Okay. So the idea that this one sliver of evidence about Michael Cohen and Trump, talking about how he needs to get repaid, would have influenced the jury verdict, it's
right.
It's fanciful. No way that would happen. So my view is the judge should have said, okay, let's assume that this Cohen Trump communications while he's in the White House to get money paid to Cohen to reimburse him for the monies that he paid off to Stormy Daniels shouldn't have been in. It wouldn't have affected the verdict. Let's move forward.
Right. Harmless error. Okay.
Yeah.
So he should not have, but now he has postponed that hearing. And do you have any predictions about how that's going to go now in light of this?
I do not think, in light of the delay, Amy, number one, I say, because we're writing on a clean slate, there's no precedence out there. Whatever he does is going to be appealed right up the ladder again, because it's an immunity issue and you have immediate appeal. So whatever he senses, whatever he does, is going to be subject to immediate appeal and the Court of Appeal. So whatever he senses, it won't have any impact upon Trump's campaign. He'll not be serving it until, at best, maybe years after 2024. This could go up to the New York system and all the way up to the U.S. Supreme Court, because the issue of presidential immunity is a U.S. constitutional issue. It's a federal question. So it could be headed back up to the Supreme Court. Maybe you can come back and talk to me in 2026 and we'll have to talk about the issue. That's how long it takes. People don't understand, Amy, how slow the judicial process is. I've got cases now been pending on appeal for a year and a half.
And he has a right to appeal it and not go to jail, for example, if he's sentenced to jail. He's not going to have to go to jail. He's just going to appeal right away and he'll be caught in the courts this whole time.
Yeah, that's right. I mean, there is a stay. But the other thing also, I think, that makes it highly improbable that there'll be any jail time is that it's one thing if the judge said, okay, you spend 2 weeks or a month in jail, even 2 months in July. By that time, he's out to campaign, in the last laps of the campaign for 2020 presidential election. It doesn't cut him off at the knees just when he needs to start accelerating because we're approaching voting day. Mm-hmm. He's in September. You're just on the edge of voting. This is the high season for campaigning, right? There's no way he's going to do that. It looks so mean and so unfair to Trump to tell him, okay, you can't go campaigning, but this is right at the height of the season. My opponents do this. So he's not going to do it. He won't do it.
You think not? Okay, so we have your prediction on that now, and then we'll see what happens in September, and we'll come back and we'll talk about it. Almost nothing is surprising me anymore in the realm of politics. Where we've got Biden, who has been shown clearly to not be competent to run for another 4 years, at least, if not removed from office now. And yet there's so many people who are still trying to prop up that candidate, that campaign, that president right now. Nothing surprises me anymore. That's all.
Yeah. It's like trying to electrify a corpse. Biden is dead. He doesn't have any brain. He doesn't have any cerebral power. All these, and the other thing that's so disgusting about him, all the concealment, all the people around him knew.
Yes. Yeah. That letter, and we're getting off because I'm going to ask you about the two other cases and the effects on those in a minute. But we'll finish this tangent because it's too interesting. Oh God. So the letter that he sent to Congress yesterday, Biden, there was language in there that said that the voters have spoken clearly and decisively or something like that, that somehow the voters voted for him to be the candidate in the primary. And so somehow that is important for everybody to take note of. And he dropped the entire context, which is that all of those voters have been duped by him, the people around him, the mainstream media who have cooperated with this whole charade this whole time. It's ridiculous. And, there's a bunch of clips that have been circulating mostly one clip, and then I looked at other clips of Ronald Reagan, and they said, oh, Ronald Reagan in his second term, he just wasn't mentally as sharp or whatever. There was that kind of myth. And I go back and I look at an interview from that time, and the guy is really, if you want to use that phrase, sharp as a tack, which was the talking point that was apparently circulated to the media to spout about
Mhm.
Biden in the last months or whatever, sharp as a tack, sharp as a tack. Reagan was sharp as a tack. Biden is, I don't even know. I don't know how that could be done. So as I said, nothing will surprise me. Go ahead and comment on that if you want to, but then we'll go to the other two
No, I
cases.
know. I mean, the comment is, well, Joe, the people have a right to know. Why were you concealing all your visits to the doctors and all the people around you are saying, "My God, you got to cover up X, Y, Z." That is, if you want to claim a mandate, you have to be transparent because the mandate is based upon what people believe the facts are. And if the facts aren't what they think they are, then you don't have a mandate. I mean,
No.
it's just truly me. It reminds me a little bit. This is not the first time, Amy, of Woodrow Wilson. He had a stroke
Mm,
campaigning for the Versailles Treaty. This was like 18 months left in his presidency in the second term. And remember, there wasn't at that time any two-term limit on the presidency. And Woodrow Wilson actually tried to run again in 1920 when he's totally debilitated. He couldn't even speak. He was not even seen for months. His doctor lied about it. His wife lied about it. His cabinet lied about it. He wasn't even able to have any cabinet meetings. His wife became a surrogate president for like 16 or 18 months.
mm.
And I mean, it's truly shocking. And the vice president didn't step in and say, well, you're disabled. I'm the president now. He was a very weak candidate anyway. So we've seen this rodeo before, and it's very, very ugly. But
Well,
Biden's not the
it was
first one.
easier. It was easier to, perpetrate, if that's the correct word, at that time because the media wasn't everywhere all the time, and it wasn't so easy to circulate footage and et cetera as it is today.
Well, yes, but they knew that didn't make public appearances for months. When
Right.
you went and looked at him, he was back on his back in the bedroom. He couldn't even prop himself up.
Yeah.
He couldn't even speak. I
Yeah.
mean, there's all sorts of books about this as Dr. Grayson covered up the whole exercise. So his wife became the de facto president for all those months. And well, the president told me to do X, Y, Z. The president wasn't even coherent. And again, what's really amazing is Amy, after he's totally, completely debilitated, he wanted to run for president in 1920. I said,
Right. Yeah, it doesn't make any sense at all. And, I don't know about Wilson, but Biden, for his part, has professed to be some sort of an altruist
yeah,
acting on behalf of the American people. And here he is blatantly ignoring his chosen duty. I mean, I don't believe in altruism, right? I don't believe that you have a moral duty to other people, but he has a chosen duty to act for the benefit of we the people, and he's just blithely ignoring that duty on, for the sake of what, I don't know exactly, some sort of, he thinks, gain to him or his family or whatever, I
he
don't
wants
know.
to remain in the presidency. I've always said, Amy, in general, with the exception maybe of the framers and George Washington, that
Mhm.
politicians are sociopaths. They are philosophically, morally empty souls who get their sense of self-esteem and importance only by being the center of attention. And they know because they have nothing serious worth saying that as soon as they leave office, no one will pay attention to them anymore, right? Because the only reason they get paid attention to because they can hand out favors as a $6 trillion government. So Biden's doing this because otherwise he's a completely empty person. What has Joe Biden ever said that is memorable, right? He's not Jefferson or Washington or Madison or anybody else. No one would pay attention to him as soon as he leaves office. He'll have a presidential library or something like that. But that's the end of the matter. I mean, in a similar way, does George W. Bush, we look to him as guidance, like we looked to Jefferson and Madison for guidance after they left office? No, he sits down there. He's a nice guy. He didn't have anything that he can say that you don't understand when you were a teenager. And so that's why they cling to office. They're sociopaths. They feel their raison d'etre is impaired if they're not in office. And that's why he's running again. Otherwise, he'd say, listen, I don't need this office. I go write my memoirs. Let somebody else do this. No, I'm clearly unfit to do this. I mean, any sensible person would see that. He's actually risking humiliating himself by doing what he's doing. Every time he stands up there, there's a risk that he'll stop in midstream and says, I don't even know who I am. Why would you expose yourself to that?
And why is his wife allowing this to happen is another question, of course, right?
Yeah, and all the family seems to support it, stuff like that. But again, it goes because if you're dealing with people who are philosophically empty and all their glamour and sense of importance comes from being in office, they'll do anything to cling there. Right. Any last desperate effort.
Yeah. Oh, that's terrible. So the two other cases, Mar-a-Lago and the Georgia case, have these already been affected that you can see by this immunity ruling?
Well, of the two, Mar-a-Lago, yes, they, in some sense, Georgia, no, because it's already been frozen, right? So,
and why was it frozen? Remind us.
Because Fannie Willis, her impartiality was questioned because she allegedly had an affair with a person she hired to be a prosecutor.
Okay.
And so they have taken that issue. Now, the trial judge said, okay, maybe she did things that were not kosher, but it's not enough to disqualify her. The person that she had an affair with left the whole office. He's gone. But that decision is now on appeal. And until the Georgia appellate court decides, everything's frozen. So the decision in Trump can't have an effect until the case is unfrozen.
Right. Okay.
But at that time, let me give you an example, however, Amy, because your question is a good one. I hope everybody on this program remembers the audio recording of a telephone call Mr. Trump made to the Secretary of State, Raffensperger, in Georgia after the November balloting. And he said, among other things, hey, you got to find 11,700 votes for me. If you don't, you're not doing your job. You just got to find. That's all you need to do. And you could be subject to criminal prosecution if you don't find those votes because that it was rigged or whatever. And Raffensperger is a Republican, right? All Georgia executive branch of Republican. He said, no, we've done this. We've recounted the votes. There wasn't any fraud, Mr. President. No, I know that there was fraud. You got to find those 11,700 votes. Well, under the Supreme Court's decision, it's a presidential act because he was still in the White House when he made the call, presumptively immune. And then you can litigate that. And then it'll go up all the way to the Georgia courts and then all the way to the Supreme Court again. And 3.5 years from now, you may be able to have a trial on that issue because that's obviously a key piece of evidence to show that he was trying to defraud the Georgia voters, out of a proper election to select the electors to vote in the presidential tally.
So that's Georgia. And then what about the Mar-a-Lago?
Okay, the Mar-a-Lago one, it pushes the envelope. But this is the theory of the Mar-a-Lago defense now, that they've claimed that Trump's lawyers have said that the national defense information that he allegedly took from the White House, national defense information, what makes the removal and retention a violation of the Espionage Act, and they were classified, that he had, when he was in the White House, he had dreamed that he was going to declassify them, even though he didn't do anything. And therefore, it was actually a presidential act to declassify that just didn't take effect since nobody knew about it. Nobody has ever said he told me that. It was just he kept it to himself. And therefore, you can't introduce those documents into evidence because they were properly retained by him. Or his decision. He made up his mind, to decide what was or was not a presidential document that he took, despite the Presidential Tapes and Recording Act that says president documents are not yours. They belong to the United States.
Right.
That was created by the Nixon. But they say that when he was there, he silently made a decision before he had actually left the White House. Hey, these are the boxes, take them to me. And therefore, it's a presidential decision. And therefore, even if I stole it, even if they were government's property, it's immune from prosecution. That's the gist of the argument. Now, whether they succeed or not, they surely are going to, again, go up for district court level. They go up to the U.S. Court of Appeals for 11th Circuit, back up to the Supreme Court. So maybe have a trial in 2026. Maybe.
And has this been put before the court in Florida already? Has it been argued, or is this
No,
something
no,
they
no,
are
no,
going?
no,
They're
no.
going to
They'll
argue
make the
this.
motion.
Yeah.
Yeah, they'll make the motion. Yeah.
Okay. Okay.
I mean,
So
it's
we're gonna
already
wait and see.
the Florida court is already operating in slow motion because they're entertaining
Right.
50 other things as well. Now, another thing that was thrown into the spanner here by the decision, it wasn't by the majority, but um, Justice Clarence Thomas, in a concurring opinion, said, "Hey, really, the special prosecutor is unconstitutional. It's illegal. Special prosecutor wasn't confirmed by the Senate." Now, that wasn't an issue raised by the case. So, kind of why did he even address the
Right.
issue?
Right.
Well, I think he was suggesting, hey, go back there. This kind of giving some guidance to Trump's lawyers. Now, but what makes that even more strange is as follows. After the Nixon debacle, when it was shown that you couldn't trust the executive branch to investigate itself for crimes. Remember, Nixon fired Archibald Cox, and there was cover-up. Attorney General John Mitchell ultimately went to prison. That Congress in 1978 enacted the Ethics in Government Act, signed by the president, that created an independent counsel appointed by 3 judges, not the president, 3 judges, to investigate crimes alleged against high-level officials in the executive branch or high-level officials in the Republican or Democratic parties to avoid conflict of interest. In 1988, in a case called Morrison versus Olson, it was said, oh, these independent counsels are unconstitutional because it takes law enforcement away from the president. Sounds similar to Chief Justice Roberts, right? You take law. Okay. Obviously, it did. The president had no role in appointing the independent counsel. And the independent counsel could serve, unless did some misconduct. And the independent counsel decided what witnesses called. They made the law enforcement decisions. I mean, my friend Ken Starr obviously was operating independently from the White House.
He was a professor of mine. I really liked him a lot.
Yeah. Ken was a wonderful person, very gifted speaker. And he served as Solicitor General and head of the U.S. Court of Appeals for many years, too.
Yeah.
But anyway, and we know Ken Starr was, he ultimately decided that he would present what arguably were crimes to the House for consideration for impeachment. But that didn't mean he couldn't come back later and criminally prosecute.
Right.
So what did the U.S. Supreme Court hold in this challenge to the independent counsel? In an opinion by Chief Justice William Rehnquist, who's certainly on the conservative side, said by 8-1 vote, it's constitutional. I don't need to get into the details. But it clearly held independent counsels who even have more power, independent of the president and special counsels, are constitutional. Well, then what is, of course, that decision runs head on with the Chief Justice's statement that says the president has plenary authority over law enforcement.
Exactly. Yeah.
He does?
Yeah.
Well, what about Morrison and Olson? Okay. What about Morrison and Olson? And John Roberts was a colleague of Ken Starr's. You know Ken Starr's. We were all together at that time. I went and talked to Ken Starr. So it's not like this is some obscure case that no one knows about. Everybody in this town knows about Morrison and Olson. So where does that come from? Are you overruling Morrison and Olson without telling us?
Right.
So why?
Right.
Anyway, these things just leap out. And I'd be the last one to try to impute some irregular motive. I can disagree with people, but I don't impugn motives. But this just seems so deviant from the customary way in which they approach decisions. It just looks very, very odd and suspicious.
Okay. Well, interesting enough. We'll see in the weeks ahead whether your predictions come true, and we'll see if we're going to be surprised by something in September with the court.
So what I have drafted, and I hope to circulate soon, Amy. I've drafted a proposed constitutional amendment to overturn Trump versus United States.
Okay.
To the Congress, you need 2/3 of the Senate and 3/4 of the state legislatures to just get it on there. We can't we can't just say we're not going to obey this. It happened. They said the Supreme Court can make errors. They made errors before, Dred Scott. We got to stick with a system. The system says if you think Supreme Court wrong, I said it's done 5 times before, there's an amendment process. It may be hard, but you just can't say, I don't like it, heck with it. That's the end of the rule of law. And we need to be faithful toward institutions, even if they seem to misfire, because the cure is going to be way worse than the disease.
And you think that they should have been the ones to get the amendment, but you're proposing the amendment to cure what you see as their mistake.
Yes, and as I say, it's done 5 times before, so this is not unique.
Okay. Well, we look forward to seeing where that lands, hopefully by next week when we actually, I'm not sure if we're going to speak next week, or there may be actually somebody else who's in your stead. I'm going to be off next week, but next time we speak, I look forward to seeing where this lands and discussing it with you.
Wonderful. And I repeat on every occasion, I'm very, very laudatory towards everybody who listens to the program. You're engaged, you care. And that's the most important element about being a citizen. You're not a spectator. You don't have to agree or anything I say, but you know the issue is important, and we can't have self-government without citizens like you participating.
100%. 100%. Thank you so much, Bruce, and thanks for everybody tuning in
Okay.
today. And
Thanks.
we'll talk next time. Bye.
Okay.